So welcome everyone. Let's go ahead and get started. My name is Camden Hutchison. I'm the director of the Center for Business Law here at UBC. It is my pleasure to introduce virtually Tomer Stein. Professor Stein focuses his teaching and scholarship on business associations, in particular corporate law and governance, M&A, and contracts. Professor Stein is also affiliated with the Haslam College of Business, where he serves as a research fellow in both Neal Corporate Governance Center and Anderson Center for Entrepreneurship and Innovation, all at the University of Tennessee. So he is a law professor at the University of Tennessee Law School and also affiliated with their business school. Beyond the University of Tennessee, Professor Stein's national service includes his appointment on the executive committee of the Business Association section of the American Association of Law Schools. His scholarly publications have appeared or are forthcoming in law journals such as the Washington University Law Review, Utah Law Review, Arizona State Law Review, and the Hastings Law Journal. And his article, The Merging of Ownership and Control, is forthcoming in the University of Georgia Law Review. Is that correct? Okay. So in addition to his academic work, Professor Stein serves as a consultant and expert witness on various business law matters generally, and corporate law governance matters in particular. Professor Stein previously practiced corporate law at the New York office of Latham and Watkins and as a legal consultant to the capital markets arm of the Royal Bank of Canada. His practice focused on capital markets, general securities, and corporate governance matters. Professor Stein's experience includes advising corporate, private equity, and banking clients on a broad range of public and private, domestic, and cross-border financing transactions, including initial public offerings, high yield and investment grade debt offerings, follow-on and secondary equity offerings, liability management transactions, and committed financings. So very impressive resume, and I'm looking forward to hearing his remarks on his forthcoming papers. So Professor Stein, I will go ahead and let you get started with your talk.
Thank you. Thank you so much. I really appreciate the introduction, and I really appreciate the invitation and having this opportunity to present to you and having this discussion with you all. I'm very much looking forward to today, and I appreciate the opportunity. So this article that I'm presenting to you today is called The Merging of Ownership and Control, and that's an article that was born out of a watershed amendment in corporate law, in particular in Delaware corporate law. Delaware is a particularly important jurisdiction, not just in the US, but globally, because all jurisdictions look at Delaware law as a model, typically, for what to do, and sometimes other jurisdictions look at Delaware as a model for maybe what they don't want to do. But at any rate, everybody likes to look at Delaware. Delaware is a leading figure in providing corporate law for many corporations, whether they are US-based or not. More than half of the S&P 500, so the largest publicly traded companies, choose Delaware for their incorporation, and at least arguably that's because of the laws provided in Delaware. And so Delaware corporate law is really, really important. And an amendment that happened over last summer and is what really brought this article into fruition, a big change in Delaware law. And you might have seen that now Delaware is in the news for a whole host of legal changes. Elon Musk is unhappy with Delaware. Meta is considering live in Delaware. TripAdvisor, who else? Dropbox. The list continues, and so Delaware has really very much been in the news, and Delaware laws have been in question. And there's a particular law that I was unhappy with, a particular legal change. This summer amendment was a change to make Delaware corporate shareholders able to enter into shareholder agreements with the corporation. So an agreement between the shareholder and the corporation that allows shareholders to tell directors how to manage the corporation. This might seem innocent, but as I hope to explain and argue for, this is not innocent, and it's a big change, and it's perhaps the undoing of what it means to be a corporation in the first place. So really, my article has two main claims and two contributions that I hope I get to make. One is that the law and theory of the corporation and organizational law generally has been lacking in theory because it treats all fiduciaries, whether they're corporate directors or agents or trustees or officers, as just functionally equivalent organizational strategies to having many contracts. It's what I call fiduciary essentialism. It's commonplace in both economic theory and legal theory. And I argue that this is just a wrong theoretical framework. And I hope to show that by dismantling fiduciary essentialism and showing the unique function and role of corporate directors as a unique type of fiduciary, we can understand that there are various kinds of firms that need to be served by the law. And secondly, once we understand the function of directors and what they bring to the ability of people to organize together, that we can see that this Delaware amendment is misguided, it should be undone, and we should stop any further proliferation of what I call merging of ownership and control, when we have shareholders able to control the corporation, when owners are able to tell controllers, being the directors, what to do. So in order to get there, I want to first start by speaking about what is this thing I call fiduciary essentialism, what is this reference to firms that I have been describing, what does the theory and law look like today, and why I think it's falling short of giving a full picture of the virtue of firms. And it starts off with an observation. The observation is that sometimes when we humans exchange things with other people, we do it by having a contract with another person, but other times we do it in groups. So perhaps I open a convenience store and somebody comes to work with me, and then me and the person who works for me in the convenience store, we together exchange with somebody else, say a supplier of sodas. This is a non-obvious phenomenon, because contracting, just exchanging things between beings, is fairly commonplace in, say, the animal kingdom. We see other non-human primates exchange all sorts of things with one another, grooming one another. We see crabs live in shells with one another. Other animals know how to exchange things with one another, but this is a very unique human behavior that we come together and then exchange together as a group with another group. And this group called a firm, we need to explain why it happens, and the law needs to assess whether it's a good or a bad thing, and if it is a good thing to some degree, the law will need to provide the necessary conditions for firms to occur. And the question is, how come that we engage in that sort of behavior called firm behavior, that where we come together and exchange as a group with other people? That's the famous question that Ronald Coase is credited for asking and answering. And the Coasean answer, which is sort of the movement for the law and economics understanding of the firm, which has been the dominant theory, is that, well, it's sometimes just cheaper and easier for an entrepreneur to organize as a firm than to have a multitude of contracts with many people. So to give a concrete example, if we go to our convenience store example, were I to try to run a convenience store, I can just have many small contracts with many people, whereby one contract will have a person standing in front of the register, we'll have another contract with somebody to stuff the shelf with various products, perhaps another contract for somebody to actually ring up items in the shelf, and so on and so forth. So that seems hard and expensive to do sometimes, and instead of that, what we do is we have somebody come to work for us under a very general description. So, hey, would you like to come work for me? And the person says, that sounds great. And now we have a firm. And that's sometimes cheaper and easier to do because we don't need to have many contracts that are with full description. Instead, we have an incomplete contract, but just one. And that is sometimes better for us to do. We see that everywhere in the market. For example, lawyers and investment professionals, we tend to like to work for firms. We tend to like to go work in law firms, not all the time, but we do that a lot. We work together, or we go work at an investment bank, or we go work at a commercial bank. But for example, musicians, they tend to have just one-off contracts with various venues. And that just depends on the relative cost, is the typical story, because sometimes it's easier to have many individual complete contracts, and other times it's better to have one incomplete contract. And that began the analysis of what it is to have a firm. We have firms when it is cheaper and easier to have an entrepreneur control the various exchanges between people than it is to have multitude of contractors, but it didn't complete the image. Many other works in both law and economics have added more to this story. Most importantly is the question of how could it be that having this incomplete contract is efficient, given that the contract doesn't say what to do in various situations that are not written in the contract. It's incomplete. For example, if the person who works for me in the convenience store needs to decide whether to buy Coca-Cola or Pepsi products, how are they to make that decision? If we have somebody hired to work for an autonomous vehicle company, for example, and a new AI technology has erupted into the market, how is that person working for the entrepreneur supposed to decide whether to adopt this new technology or not adopt this new technology? The contract is not going to tell them what to do. And if this contract is incomplete and it's not going to tell the person hired what to do, how could it possibly be efficient and cheaper? The answer, conventionally, is that whenever the contract ends, the residual claimants get to decide what happens. That's what it means to be a residual claimant. What it means is, and the entrepreneur, the person who hired, the fiduciary, gets to tell the hiree what to do in case of any disagreements. There are residual claimants because any residual of the contract is left over to the claimant, the owner, the entrepreneur, to decide. And so that's what it means to be an owner in a firm, according to this theory. You're an owner because you didn't just contract for various things with the person who is working for you. You also acquire the property rights, the ownership to tell the hiree what to do when the contract does not. Hence this insistence that it doesn't matter what fiduciary we hired. It doesn't matter if that fiduciary is a director or an agent or a trustee. Those are clerical legal distinctions that us lawyers need to worry about, but they do not matter functionally from an economic perspective. They don't really matter too much, because what matters is that we have a residual claimant who gets to decide what happens when the contract doesn't say so, and another person who is beholden to that residual claimant, any type of fiduciary. In the legal theory, the way this is described is, fiduciaries have fiduciary duties, whether it be care or loyalty or good faith, or depending on some jurisdictions have more specific articulations, but all those fiduciary duties do is basically execute the wishes of the residual claimant. We have to imagine what the residual claimant would have wanted to do had the contract been complete, and that's what we do. We just we play the counterfactual game, and the residual claimant at the end of the day is the one who gets to have their wishes heard. If that is all true, I think we can say that this amendment that happened in Delaware is sort of a non-event. Of course, shareholders should be able to specify in the contract what they want the directors to do. After all, they are the residual claimants, and that's what it means to be an owner. It means that they have the right to tell people what to do if the contract doesn't say so, particularly the fiduciary. So let alone let them specify it in the contract, I think that should be a rather obvious conclusion. And so perhaps that is part of the story of why this amendment was adopted in record time, despite people feeling that there is something awfully wrong about it. So there was a lot of objections to this amendment, just not grounded in any particular theory. Well, and it is exactly at this juncture that I intervene in the existing literature, and I disagree with this typical image that the entrepreneur is faced with just two choices, either having a multitude of contracts with various contractors or having this residual claimant firm contract. I think we have another kind of firm that this theory has missed, which is what I call my theory of residual obligors. And that's the firm that results from this residual obligor structure is what I call the manager-led firm. So If we go back to our image of not our image, but our example of the convenience store and the incomplete contract, it's correct to notice that we need to give an explanation for why a contract that's so incomplete and missing so much guidance and direction for the fiduciary as to what to do in future events needs some explanation as to how such a contract can be efficient. But it's a mistake to then quickly jump into concluding that there is only one solution to this incomplete contract problem, and that solution is for the owner to tell the manager what to do, the manager being the fiduciary. There is another solution, and that is whenever the contract doesn't say what to do, the manager should be the one to decide what to do. That is that diametrically opposed solution to the typically understood structure of the residual claimant structure in fiduciary essentialism. The question is whether I'm just theoretically correct that this could be a solution, or whether it's actually something that shareholders would want and is efficient and functionally desirable. And I argue that it is efficient and functionally desirable in some cases. And this is really important, not in all cases. In some cases it is. And the question is, what sort of cases would a manager-led firm be more efficient than an owner-led firm? And the answer to that is when a manager-led firm solves various coordination problems of people coming together and being able to form a firm. There are two kinds of coordination problems that people encounter when they want to come together and manage an asset properly. One is famously known as tragedy of the commons, developed by Harding, and this is the idea that when many people have ownership claims over an asset, in Harding's example would be a pasture, and many people having the right to let their cattle go into the pasture, people will be in a situation in which they have an incentive to overuse the assets to its abuse. While we would hope that everybody would cooperate and only graze as much as they need and limit the cattle so that the pasture can succeed for many, many years, people will always be worried that other people will use more of the pastures than they will, and they will be in a race to the bottom to the point of depleting the assets and destroying it for other people's enjoyment. So, and this same sort of mechanism occurs in corporations as well. For example, if shareholders were able to pull dividends out of the corporation whenever they felt like it, they will always be worried that somebody else will pull cash out of the corporation before they would enjoy any value from the corporation. And so we let directors decide when to pay dividends. So that's how letting manager make decisions solves commons issues in the corporation. That commons problem in the corporation, what is important, that doesn't do enough to justify by itself a manager-led firm, because theoretically the shareholders should be able to contract together and say, okay, we know that we shouldn't just pull dividends whenever each one of us needs it individually. We can sort of waive our right to do it in some kind of contractual agreement. And that's true, and I agree with that. The issue is that we have to account for another coordination problem that happens when many owners come together, and that is the tragedy of the anti-commons made famous by Michael Heller. The way this works is that it looks at the opposite problem. When many people have an ownership claim, when too many people have ownership claims, it could create an underuse of the assets. So when we have too many property rights, it can sometimes lead to underuse of something that could be useful. In Heller's example, he gives the idea that many people with patents that could, in theory, come together and coordinate to create an Alzheimer medication were unable to do it because it was too expensive to contract their various rights of doing that. It's just contractually too expensive for them to do that. Another example that occurs here, I worked at the University of Tennessee, as was mentioned earlier, in this region of the US called Appalachia, where we've experienced in this problem of heirs properties. What this problem is that is the way this problem plays out is that we have large families who are each inheritant of big tracts of land, but there are many family members with each many small claims over the property. that people left for them, but they're not able to coordinate themselves effectively. And then a developer comes and is able to take advantage of them, buy the land very cheaply, and basically extract all the value away from all the heirs. The same thing happens in corporations sometimes. When owners want to come together and coordinate, for example, coordinate some mechanism for them not to extract too many dividends away from the corporation, that is only possible if there are not so many ownership rights divided amongst the various owners, so they're actually able to coordinate effectively together. And many times, and particularly for larger firms, maybe public firms, that's not possible. It's not possible because so long as so many people can potentially have a residual claim at the end of the day, so long as it's so hard to and expensive to coordinate contractually, it becomes impossible for them to actually come up with a good organizational solution. So when we combine these comments and anti-comments issues together, then we end up in a situation in which the only way to solve it is to create some kind of opt-in mechanism by which people can say, no matter what, so long as we form this entity, the manager will get to decide. Nobody else gets to contract around for whatever right they want. Nobody gets to extract rights. Nobody needs to coordinate the property rights in order to achieve that. And that is precisely those situations in which we want to have what I call a residual obligor, a contract in which any matters not specified in the contract are going to be left to the residual obligor. So instead of making ownership rights very clear, we make them blurry, and we make control by the manager very clear, instead making it a very effective organizational solution, again, in some cases. That is very important. Manager-led firms are not here to replace owner-led firms or contractor arrangements. Various factual situations will call for various different types of organizational solutions. The point is that we need to have one legal avenue. We just need to have one legal avenue to create manager-led firms. At least one legal avenue to have owner-led firms, and at least one legal avenue to have contractors. Until this very day, until this amendment has been adopted, we only had one way to create manager-led firms, and that is to enter into a corporation, as per Delaware's law version of corporations, which exists in other jurisdictions as well. The reason that Delaware's corporate law allowed for manager-led firms is because there was a statutory rule that said very explicitly that only directors get to make managerial decisions over the firm. It is their privilege and duty. And it was the case that shareholders couldn't tell them what to do, even through things like bylaws. So Delaware law says shareholder-adopted bylaws may not contain any substantive directives as to how directors are to manage the corporation. Ipso facto, and there was also some precedent for that, shareholder agreements were also not allowed to be used in that way. With regards to the charter of the corporation, there I have to admit that descriptively, as the law was structured, it was a bit more questionable. So people like me say you couldn't use the charter in any way you wanted to tell directors what to do. There was some confusion. There was some precedent that says the opposite, that maybe they could tell the directors what to do in the charter, at least in recent decisions in the Chancery Court. But description of the law aside, normatively, that we can say the value of Delaware's overall structure has been in insulating managers from the whims of shareholders. Directors had some sort of independence. Now, that means that this amendment allowing shareholders to now tell directors what to do eliminated the only legal path for manager-led firm. And if manager-led firm serves a huge portion of our economic activity, or at least a portion we want to protect, we have to undo this law. Otherwise, we're going to lose profitable economic activity, which is going to stop people from being able to coordinate and contribute to society. So this law is really bad, and I expect that after it's clarified through the court, that we will see some serious economic consequences as a result of this law that we can empirically test for. I think that other jurisdictions, as to look to Delaware, should not adopt this provision. And I think it's also important to consider the context of when this decision was adopted. So the case that brought this decision was as a result of a lawsuit against Moelis. Moelis being a bank that was started by a famous founder who then wanted to make the bank into a public corporation, but still control it. So Ken Moelis still wanted to control the bank Moelis, but he wanted to tap the public markets as a public corporation. So the Moelis tried to use these shareholder agreements. And so the same thing that we see with other controversies in Delaware with people like Elon Musk and Mark Zuckerberg. Now we see that we have these sort of strong founders trying to retain control of the corporations, yet still maintain decisions as to how the corporation is going to be managed. But those, without getting into the facts of any particular case, if they wanted to do that, there are other ways to do this. They can use an LLC. They can use a closed corporation. They can use public benefit corporations. There are many, many business entities that allow people who want to organize in this way and use the residual claimant structure. There are many, many business entities that they can take off the shelf and use in order to achieve their goals. It's unclear why they should want to use the corporate form in order to achieve that. To me, I don't see the value in allowing them to use the corporate form, because if it's really true that this is the best way for them to organize, then they have other ways of doing that, and there is absolutely no reason to undo the one legal mechanism for achieving the residual obligor structure. I want to, before I conclude, to acknowledge some limitations on the legal framework I'm suggesting. We are able to tolerate certain external limitations, even within this residual obligor structure. For example, a corporation can have a provision that says what is the purpose of the corporation. The corporation's purpose can be general, as people like to typically do, such as conduct some kind of lawful activity, or if they're interested, if they want to, they can create a very narrow corporate purpose, such as this corporation is to exist for the purpose of developing an Alzheimer medication. These sorts of limitations, I think, we can tolerate within the residual obligor structure, because that still leaves the directors with the option of deciding things such as, well, we're going to invest in real estate in order to hedge our revenue results from developing an Alzheimer medication. There is no provision or ability for the shareholder to say, this is how you should invest, this is how you should develop the Alzheimer medication, this is when you should pay dividends, this is when you should adopt a buyback program. So we're able to tolerate external limitations so long as they don't amount to an interference with the substance of management decisions. So if the corporate purpose was to manage the corporation according to the wishes of shareholder X, that would not be allowed. But just narrowing the circle of economic activity, I think that could be tolerated even within the residual obligor structure. And so, sort of to conclude this presentation, I'll go back. My theory interjects with this idea that we can talk about corporate law as just agency costs and principal costs, agents being the managers, principals being the owners, the shareholders, the residual claimants, and that they get to decide what to do when the contract doesn't say so. There are other ways to solve the incomplete contract problem, and that other solution is the adoption of a residual obligor. And our laws should be designed to allow people to pursue this very effective way of organizing whenever that's warranted, which is not all the time, but it is important in some cases. The corporation is the only legal way that we've been able to pursue this way of organizing, and this amendment that allows shareholder agreements to interfere with the managerial decisions of directors should therefore be repealed and not adopted in other jurisdictions. Thank you.
Okay, thank you very much. Yeah, round of applause. That was super interesting, and we have plenty of time for questions. I'm going to go ahead and ask the first question, and then I'll turn to the audience. So I want to ask a question, and this actually relates to my own research. So I was really interested in your paper. It's actually quite relevant to and complementary with an article that I just finished, and I've just kind of submitted in the current round of U.S. law review submissions. But basically, what I did is I did a pretty large comparative study of corporate law rules in different jurisdictions around the world. So I looked at sort of 60, commercially significant jurisdictions around the world and kind of compared corporate law rules. And I didn't really make a normative argument in the article, but what I found descriptively is that Delaware is actually quite unique among international jurisdictions in its traditional grant of strong discretion to directors to manage the company, independent of shareholder interference or meaningful shareholder oversight. And obviously there's oversight. But the main difference I found is that in most jurisdictions around the world, although shareholders generally don't have a direct right to sort of call the shots and make decisions, they have very, very strong rights to essentially remove and replace the directors at any time, which is much more difficult in Delaware. And so I found that Delaware is actually, at least historically, has been a very sort of pro-director or kind of director supremacy jurisdiction compared to most jurisdictions around the world. And so I make a positive argument that Delaware's development to this sort of strong pro-director framework, which you argue may be undermined by this recent amendment. I argue that may be well suited to the sort of stereotypical Delaware corporation, which has historically been owned by highly diffuse shareholders who face very significant informational and coordination problems, exactly like you argue, right? So that it makes sense to have strong directors who can coordinate these sort of, diverse interests of kind of rationally, relatively uninformed shareholders. And that in other jurisdictions around the world, including Canada for that matter, shareholders have much stronger rights to replace the directors at any time. And that makes sense in an international context in which most jurisdictions around the world, public companies are characterized by controlling shareholders. So you have powerful controlling shareholders who control, I don't want to say most, but certainly in some European jurisdictions, probably a majority of publicly traded companies are controlled by strong controlling shareholders. And that makes sense because you have a much less serious coordination problem and even much less serious informational problem where you have a single dominant shareholder. And then obviously you sort of have, you have this other problem of potential exploitation of minority shareholders. But I don't really get into that too much. So I guess my question is, you make a pretty strong normative argument in favor of strong directors. And in your mind, would that also apply to kind of non-US jurisdictions where maybe stock markets are not as deep and you have more controlling shareholders?
Thank you so much, and I would definitely love to read the draft whenever that's available. That sounds fascinating. So I have a few responses to this. This is really interesting. So first, sort of the empirical point that you found that Delaware is more director primacy than other jurisdictions. I guess you can take it in two ways. You can say, well, that's perhaps an empirical result that undermines my theory, because if my model was so good, then perhaps other jurisdictions would adopt it. The other way to look at it, interpret this, is to say, well, maybe that's why Delaware has been successful for those public companies, those dispersed ownership companies, and so that could be interpreted as supporting my theory. And I guess both ways we can argue about it. Sounds like actually you're more sympathetic towards the latter. I just wanted to acknowledge it. I guess somebody could use it too to fight against my theory. I do think you're right that it makes sense when we have a strong controller that they should have more power over the directors. I didn't talk about it as much in the presentation, but I talk about it in the paper more. We can talk. There is this thing called the separation of ownership and control. So the way this works is the shareholders, they own the corporation, the directors, they manage the corporation. And as a result of separating ownership and control, we create various costs that agency theory tries to address, and the problem sort of reduces to we're managing other people's money. And I know many of you are aware of this, but just make sure for everybody's edification, I'm going to describing the model. And so when we have a controller, perhaps what we want to do is we actually want to give the controller power, because we think that's a better way of reducing those costs between shareholders and directors. And when we don't, we think that the costs are going to be higher actually if shareholders exert their wishes. We want to reduce what's sometimes known as principal costs. Then we go to my model of residual obligors. So as far as what other jurisdictions would do, I think, I'm just arguing for expanding the options, the menus off the shelf that exist in the law. So I don't think it would hurt other jurisdictions to adopt this residual obligor strong corporation, but I just think it probably won't benefit them that much because they don't have that many people who need that form of organization. They already are using the Delaware form. But if the courts would interpret this new statute in a way that accords with the statutory, with the legislative will, that's still to be decided, then perhaps another jurisdiction can emerge. I can see something like some kind of British London-centered market for charters emerging if Delaware is really going to be undone in such a way. It seems sort of fantastical to imagine now, but in theory, that's possible. Perhaps some Canadian locations. So my answer is, I think they can adopt it. They won't hurt anybody as long as they don't undo the ability of people to use this residual claimant structure. The other response I have is about this distinguishing leverage of hiring and firing from giving directions, the right to give directions. I think those are two different powers of shareholders. I have no problem with shareholders being able to hire and fire the residual obligors. I don't think that defeats the purpose. I analogize that to the political process. So when we elect officials, we can in theory hire and fire them, and that's okay. But we feel in many countries, once we have an elected official, they're not beholden to any one voter. They can be hired and fired, but they still make their decisions as they please. They just answer to the leverage of being hired and fired. And so that sort of leverage by shareholders over directors, I don't think that defeats the residual obligor structure.
Interesting. Thank you. I do have a follow-up question, but I will take my turns. So to call on people in the audience. So I saw Maziar, you had your hand up. Yep. So please go ahead.
Okay. Thank you so much for the very interesting talk. And I love your paper. It's such a great contribution. I have two quick questions for you. So I totally understand your critique of law and economics, but I was thinking about how corporate law operates and how we understand fiduciary duties under corporate law. And I think it's actually quite consistent with your theory, in the sense that as fiduciaries, corporate directors are not beholden to the wishes of individual shareholders, right? So you have to act in the best interest of the corporation, but you're not their agent. So I think both jurisprudence and statutes make it very clear that, you have a board-centric model of governance. So I think actually that adds to the force of your argument. The second question, so I'm working on this project on the remedies that you get if a merger agreement is breached. And I mean, you're the expert on this. You know that Delaware has also passed this amendment after the Twitter case that allows shareholders to sue for the recovery of lost premiums. And it's interesting in the sense that people who write in this space, they're advocating that's the right model. And I share your concerns because it just doesn't make any sense, that you give the shareholders to sue for premiums. But it's interesting that, all these decisions like the Twitter decision, for example, I don't know what's going on with Delaware, but there seems to be a very strong backlash. And now you are seeing, people lobbying for very foundational changes to Delaware law. So I would be very curious to hear your thoughts on that part of amendments as well. That
No.
also think that actually they really disrupts the board-centric model of corporate law that we have under Delaware, or even in Canada, to be honest with you. Yeah. Thank you.
Thank you. Thank you. I love the questions. Yeah, I think I should say with you, you're in good company. I got an email from Vice Chancellor Laster objecting to my article in the same way as to your first. The law is already account for that. But here's my response to that. You can find a lot of cases in Delaware that say, directors are not agents of the corporation in the legal sense. They're not trustees in the legal sense, but they are agents and trustees, and they're not. It's not the way the decisions are always written. They're not in the legal sense, but we use the agency model to understand the way fiduciary duties work, etc. So, they're sort of dancing on two weddings from my perspective on that topic, and so yeah, there is a legal distinction, but I don't think that the law has taken this legal distinction seriously enough. And I agree with you that it used to be that way in Delaware, but last year's very decisions, the decision in Moelis, whereby he basically said, yeah, the shareholder agreements were invalid, but they could use the charter to accomplish the same thing. I think that makes directors essentially agents. And so even if it didn't exist before the Moelis decision, it existed right after the Moelis decision. I thought it was a deviation from the law. I admit that there is some, I cite some cases that say what I think, and I cited some cases that don't say what I think. So I admit that there was some ambiguity as to the charters. But I think that as soon as you allow shareholders to interfere, it doesn't matter whether it's the charter or the bylaw or shareholder agreement, then you have defeated the residual obligor structure. Because let's think about the difference between an agent and a trustee. The only difference between an agent and a trustee is that an agent can get their instructions ex post so principals have the right to provide agents with interim instructions as the relationship ensues. That's an element in order to form a principal-agent relationship in a legal sense. And for a trustee, the settlor, the person setting up the trust, just needs to put all the instructions ex ante. So the only difference is whether the instructions by the person who is setting up, the owner at first place, is going to come ex ante or ex post. And so from my perspective, it doesn't matter if you allow shareholder agreements to give instructions or the charter to provide instructions. In either case, you have pushed directors into the residual claimant structures. You have treated them as essentially like agents. And so that's the critique of the law as it stands, whether it's through the legislator with the amendment allowing for shareholder agreements to do it, or the decisions of the Chancery Court that allow shareholders to do that through the charter. So you ask about the M&A remedies question, and I may even lump the ratification question. So if some of you may be aware too that Elon Musk had a compensation package of $56 billion. The court said it was invalid because it violated the control of fiduciary duties, and then the shareholders voted after the fact to ratify the compensation package, and the Chancery Court says no such thing as ratification. I think we can consider that and the remedies of shareholders and the shareholder agreements together, because there is really, as you alluded to, a really big moment as to how we're going to distribute rights between shareholders and managers. To answer this, what I think about it, I do think that
sorry, just to clarify something, I was referring to the CRISPO case, not the compensation package. So the CRISPO case, they said that the shareholders cannot directly sue for the promise premiums or the loss premiums, right? And now the Delaware Legislative Assembly is actually overturning that decision and saying that no, if you agree to it and put it in the merger agreement, then you could sue for it.
Yeah, sorry, I understood that I meant to also add the ratification. to consider all of those together, because I think it's a good point that all of these changes together should be considered. And I have to use something that's not in the article you read for today, but it's a sort of follow-up piece that I'm working on right now in order to answer this. And so I can present this residual obligor versus residual claimant structure from a jurisprudential perspective rather than a law and economics perspective. Some of you may be familiar with Hochfeld's dual relations. I won't explain the whole thing, but just to give enough to understand my point is that when we say that shareholders have rights, as we like to do in corporate law, in jurisprudence, things are much more detailed than that. We can't just say rights. We have to get a little bit more specific. Most importantly, there's this distinction between claim rights, which correlate with the duties. So that's the idea that I have a claim right over my house, which means that somebody else has a duty not to interfere with my house, and something like a power. Power is this idea that I can change the underlying claim right duty relationship or other sort of dual relationship. So a typical example would be if I offer somebody to enter into a contract, they have the power of acceptance. That means that if they accept, they've changed. Now they're going to have the claim right over what I offer them, and I'm going to have the duty and vice versa. What's special about principals is that they're supposed to have powers. They have powers over agents. And shareholders are not supposed to have powers. They're only supposed to have claim rights, from my perspective, if I were to state it jurisprudentially rather than economically. And so I have no problem with allowing a claim for premiums in an M&A agreement. I do have a problem with ratification because it becomes power.
Thank you very much.
Any other questions in the audience? Any questions online?
No.
All right. So I guess I'll ask a question, and this is sort of a general question, which is maybe a bit off the topic of your paper, but I think Maziar's question, sort of raised the issue of the Tesla litigation and striking down Elon Musk's pay package. And so I wanted to ask about, it seems like we're in this moment right now where there's a unusual amount of controversy around some of the decisions of the Delaware court. There's a lot of commentators who disagree with some of the recent decisions. There's commentators who agree with the recent decisions, but you see, Tesla leaving Delaware. Then I think Dropbox is leaving Delaware. Meta is like vaguely threatened to leave Delaware, I think. So you kind of have this. This is just in the last couple of weeks or so. You have a number of companies either leaving or threatening to leave Delaware, primarily over what they perceive to be excessive restrictions on controlling shareholders to manage the company or to make compensation decisions. And so I was just curious as to whether or not you think that this is just kind of a temporary stir that's occurring, or is this something that's going to have longer term consequences? Like, do you expect that companies might actually leave Delaware? And do you think, the sort of the issues that you identify in your paper, I mean, do you think that they maybe are relevant to that? Or do you think that, I guess maybe to ask a broader question, this is kind of like the big question everyone's asking, is like, is something going wrong in Delaware, right? Like, is this a serious problem where either the Delaware courts or the Delaware legislature need to course correct in some way because they're in danger of maybe losing this really, really valuable, franchise tradition and killing the golden goose?
Yeah, absolutely. That's a very important question. I think that, first of all, I'll say that unfortunately, because of all this big political drama over what's going on with the reincorporation, that means that nobody is going to listen to my proposal, because it will only serve to give Elon Musk and others the power to say this is exactly what's wrong with Delaware if they listen to me. But I do think that there are different things going on. So there's a really big difference between Tesla reincorporating in Texas and something like Meta moving out of Delaware. The difference is that Tesla has significant operations in Texas. And so What that would be, it would just be a home incorporation. And using home incorporations in order to protect against takeovers and hedge fund activism, that's just not new. That's not new. So, for example, in the 80s and 90s, when we had the big hostile takeover waves, we had states like Massachusetts adopting rules that required all their home corporations to have a staggered board so that they can resist takeovers and hedge fund activism, because it would take 2 more years, as much as 2 more years more than it did before, to replace the board. They actually required all the corporations to do that, and that was to protect Gillette and some other home incorporators they had there. They wanted to protect their directors. We have that. We had it in many other jurisdictions. So I think we had it with Boeing in Seattle. We had it with a few others, and so I think that Tesla moving to Texas is pretty normal. They have this controversial entrepreneur who has delivered economically, created a ton of revenue. That's why he was entitled to all these payments. He has all sorts of idiosyncratic visions for the corporation, and shareholders think that they need to protect his idiosyncratic visions from shareholders interfering. And so that's pretty normal for me, from my perspective, that they're doing a reincorporation in Texas. If Meta were to move to Texas, that doesn't make sense from that perspective, because they have no operations in Texas. What I think is going on there is just some, I think, marketing. So in the same way that it's cool to do crowdfunding sometimes, even though financially it might not be the best way to raise money in a startup, but it gives you a lot of marketing value. I think Mark Zuckerberg is in a rebranding phase. And I think at least saying this out loud is attractive. So now it's kind of a cool thing to move out of Delaware. So I don't think we will see a big, what people call Dexit, because it doesn't fit a lot of corporations. It does fit home incorporations, but that's not new. So it's not mass doing. That always happened. We might see a few companies take advantage of the political moment in the United States and sort of, fly the libertarian flag and use that in order to drive shareholder price. And that's, I think, what's happening with Mark Zuckerberg right now. But I don't see that as a huge economic threat overall. Especially since if you have a controller that wants to continue to control their business in Delaware, they can use Delaware LLCs for that. That's what Delaware LLCs have great precedent, and that's a really good way for them to do that. It's sort of disingenuous to say that Delaware doesn't let owners do what they want to do. They just need to pick the right entity, like a statutory close corporation allows you to do that, an LLC allows you to do that.
Yeah, thank you. I actually completely agree with you. I mean, my suspicion is that this is just sort of a temporary flash in the pan. Although I hadn't thought about it in terms of, Tesla reincorporating, like in a sense, almost to like its home state. I actually hadn't thought about that way, but I agree with you. That does seem to be what's going on. It seems to be a situation where they're reincorporating where they have a lot of operations in order to protect their existing management structure and to protect Elon Musk's control of the company. So that actually makes sense. I mean, I personally don't think that there would be big or any advantages for most companies to move to Texas, which doesn't have as well developed a corporate jurisprudence. It seems kind of risky, frankly. But yeah, I guess we'll see what happens. Any other questions? I guess so. I guess one question I had just technically. So I looked at your paper, and it's already forthcoming. So I imagine you're not really looking for any kind of comments or suggestions at this point. But I'd be happy to send you the paper that I'm. So Mazi and I, we both teach business organizations, and so I mean I don't want to speak for you, Maziar, but for me, like I teach Canadian corporate law, obviously, but Delaware is always in the background. So I feel like we think about Delaware a lot, but I wouldn't claim to be an expert on Delaware law. So it's sort of it's good to get the real experts in the room.
Absolutely, yeah, that was great. Yeah, thank you.
So if there's no other questions, I think we can call it. Yeah, so thank you so much, Tomer. It was really great.
Thank you.
And appreciate it. Thank you.
It was a great thought, and thank you so much for organizing camp.
Yeah, round of applause again.
Thank you so much for having me and inviting me. I really appreciate it.
Thank you, and great meeting you.
Likewise.